Thank you, Avani, for your kind words. I'm very glad to be here. I'm very happy to be invited for the program. I'm thanking you, all the persons who are working behind this kind of program, especially a film on environmental and climate issues. I'm glad that we have a museum like this where we can sit together, think about the common issues that the whole humanity is facing. I'm glad because when we are living in an era where issues are being compartmentalized, the history people don't want to know about politics, political people don't want to know about history, or both don't want to know anything about environment. When we talk about one issue, people will say that is not my subject. I'm not working on that field. So now we are reaching in a consensus where environmental issues are of all, irrespective of its division, the sector, etc. I was asked to interact with a few people on environmental policies, environmental legislations, environmental litigations, my experience with the environmental litigations for the past 10 years or more. First of all, I would say that it is very rare for a lawyer to get an opportunity to speak about his litigations. Why? Because generally lawyers are duty bound to take any matter that he is asked to. As per law, a lawyer cannot deny his service or her service to any client by saying any kind of ethical or other moral issues. So usually we say lawyers are jack of all trades but master of none. Litigation starts with the court and ends with the court. Litigation won't travel beyond the four corners of the court. So why? Because it is an inter-party dispute. Every litigation is an inter-party dispute. Who is the other party? It can be an individual, it can be a group of people, it can be a state. When constitutional courts are concerned, like Supreme Court, High Court, there is no inter-party dispute between two parties in general. Because if you want to file a writ petition, necessarily you have to plead that you are facing a violation of a fundamental right. A person's fundamental right can be asked to be implemented only against a state. So always in a litigation where state is the other party, then only you can raise a question of violation of a fundamental right. Essentially, in high courts and Supreme Court, or even in tribunals like National Green Tribunal, generally state will be at the other end. The dispute between a citizen or a person versus the state, that is happening in constitutional courts. So beyond the scope of a litigation, the issue will not travel because, as you know, the discussions outside the courtroom will influence the court in some way or the other, through media reports, through other communications. Judge is also living in the space where we are also living. So this can affect the pending litigation, so that there is a general bar against the discussion about a pending subject in a litigation. That is called sub judice. But as far as environment is concerned, it is unlike other subjects. It is a subject where the judge is also a party to the litigation. It is very rare to happen. Because when we are agitating a question of right to get unpolluted air in the city of Cochin, the judge is also getting the benefit of the litigation. Judge is also facing the same issue. When we are raising a question about the pollution in Periyar River, judge is also drinking the same water. The opposition lawyer also drinking the same water. The son and daughter of the parties who are concerned, it can be a state, it can be a polluter, they are also facing the same issue. In public interest litigations, the issue is common, the approach is different. Respondent may have different approach to that. Coming back to the subject, we lawyers who are fighting for environmental causes always used to tell to the court that the court should also support the cause because it is not an inter-party dispute. It is a dispute where we are parties. The present generation is a party and the future generation who is not present in the court is the other party. Environmental jurisprudence in India have developed in 1970s. We know the nation is developing with its constitutional mechanism like legislation, executive and judicial. Legislation converts constitutional ideas into statutes, laws. We have some constitutional ideas like right to life, personal liberty, right to free movement, etc. Right to equality. Such concepts have been formed into some articles in the Constitution. When we are reading Constitution in 1950, we don't recognize right to unpolluted air as a part of fundamental right. Because there was no such reading to the word right to life. When we are severely facing pollution issues, the Honorable Supreme Court has recognized right to get unpolluted air and water into the right to life, which is already written in the Constitution. So we are expanding the scope of right to life to the most possible extent. That is called evolution of Constitution. When we are recognizing a right, that right will be evolved into further rights. Every human right which is not recognized by any law will be transformed into a constitutional right. Slowly, when the entire society is recognizing that as a right, then there will be a discussion among the society to convert it into a implementable law. We had right to information, to get information from the government about our day-to-day affairs. It is essential, it's a part of the Constitution because without right to get information from the government, no person can survive. But it is not written in the Constitution that right to life, right to get information is a part of right to life. So only in 2005, the entire country or the parliament have evolved into a stage where the parliament recognized right to information is a right of every citizen. It is a part of fundamental right. So they passed Right to Information Act. They are transforming one constitutional right into an implementable right where people can write to the nearest authority, they can get the details. If details are not provided, the state will punish the officer. A corresponding duty is created within the state. As far as environment is concerned, from 1950 to 1970s, we didn't recognize that there is a word called environment. Every law is a result of the awareness of the social strata as well as the legislator of that particular time. When legislature is recognizing a right, it becomes a law. If you are noticing from the laws from 1950 to 1970s, There is not even a single word of environment in any of the legislations. We are talking about mining, we are talking about converting of agricultural lands into non-agricultural purposes. There are so many laws, industrial laws, labor laws, but there is no word called environment. Why? Because there was no awareness about environment. In 1972, due to the world famous Stockholm Convention, we have slowly understood what is the purpose and intention of the environmental protection, what is the importance of the protection. Our Indira Gandhi have gone to the Stockholm Convention and made an excellent speech and recognized the importance of environmental protection. Starting from 1972, we have Wildlife Protection Act. Then we have 1980, we have 1974, we have a Water Prevention and Pollution of Control Act. Water pollution was recognized as an issue. Air was not considered at that time in 1974. Only in 1980, the nation recognized the need of a Forest Conservation Act to preserve the forest in the country. 1980. In 1981, we have evolved from water pollution to air pollution through several litigations, especially the Meili Yamuna case, the Taj Mahal case, the world famous trapezium Taj Mahal case, where the walls of the Taj Mahal got affected with the air pollution, where the Honorable Supreme Court has directed the central government to consider the issue. So air pollution was recognized as an issue, and a national mechanism like Central Pollution Control Board, State Pollution Control Board, all have come into place. I'm not going into such details, but if we see the evolution, we can see that the social awareness about an issue becomes the legislative understanding of a country, and where a legislative consensus is made, we will get a new enactment for implementation of those ideas. From 1981, we travel 4 more years to reach 1986, where the parliament of the country understood the word environment. There we got Environmental Protection Act 1986. After Bhopal tragedy, you all might be heard of Bhopal tragedy, where a polluter has escaped from the country. Huge hue and cry happened in the country, where we were raising slogans against the polluter, where the central government has come up with a solution of Environmental Protection Act. That is called as Umbrella Act of Environment. So Environmental Protection Act defined what is environment. It is a complex relation between the living beings and the non-living beings. Even then, biodiversity and its importance were not recognized by the parliament. There was no discussion because the word environment itself was heard in the parliament at that time only. Thereafter, so many rules have come, like ozone depletion was there in 1990s. We have got a new rule for that. Plastic menace, we brought a legislation, specific legislation for that, subordinate legislation for that. Plastic rules. Wetland conservation was raised as an international issue in the Stockholm Convention. It was converted into a treaty. Then we enacted national wetland rules. So many regulations are there. Each regulation talks about or recognizes the duty of the state to protect the environment. Who will implement this? The assumption is that the state will implement this. Generally, it won't happen. Why? Because there is no stakeholders. Every law is implemented only if there is a stakeholder. How will you get an information if it is not genuinely published by the state? We will file an application by giving 10 rupees stamp. Every applicant in a right to information campaign brings more transparency into the system, so that the system gets more transparent and people will get more information. But there is no such stakeholder concern in environment sector. Only if there is a saying in Malayalam, കരയുന്ന കൊച്ചിനെ പാലുള്ളൂ. So there should be a demand from the civil society side or citizen side, then only the laws in the country will be implemented. The law will not act of its own. Why? Because who is the beneficiary of we have seen this movie related with the climate change related laws and its implementation. We can see that the beneficiary of a non-implementation of an enactment will be companies or persons who are financially benefited with the non-implementation. There is a stakeholder who don't want to implement the laws. There are people who don't want to convert any further constitutional rights into a statute. Starting from 1986, we have reached in 2002 where we got Biological Diversity Act. But even in 2023, we don't have a Climate Change Act. We are facing a severe threat as a global community. We are facing a severe threat. Probably the highest threat that we are facing as a community. But we don't have a law to take care of climate change issues. Who will recognize the climate change issues? Who will take mitigative measures? Who is responsible for not taking the mitigative measures? Who will protect the persons who are directly impacted by the climate change issues? We don't know because we don't have an enactment. Suppose you file a litigation before a court, like Kochi, some part of Kochi is sinking, west part of the Kochi is sinking due to high sea level rise. The court will say we are helpless. Why? Because there is no enactment. There is no provision in any of the statute to deal with a climate change issue per se. We may have some other laws to deal with the practical difficulties of the area, like Disaster Management Act is there. You can manage some part of it through disaster management, but where is the legislative part for addressing the issue in a legislative manner, in a manner not to law? Who is the authority for a person to go and ask the remedy? There is no one. Why? The Parliament of India has not recognized climate change as a issue, or they have not transformed our constitutional rights to get equality against discrimination into a climate justice right. Climate justice right is there. It is all over the world. It is there. It is recognized. What is a climate justice? Climate justice is a justice which is an integral part of intergenerational equity. Intergenerational equity simply means every generation has a right to develop, but that should not curtail the developmental aspirations of the future generations. We should not curtail the future developmental aspirations of the future generations. When we take sand, when we take a resource like building stone or oil or whatever, we call it a resource. We should not take it to a level where the future generations are facing a problem. They cannot use it at the level that we are using. Then there should be a ban, there should be a bar, there should be a restriction for our use of resources. So when intergenerational equity is declared by the Supreme Court as a part of our constitution, polluter pays principle is there. Those who pollute shall pay for mitigating its impact. That is a part of the constitution. Precautionary principle is a part of environmental jurisprudence. Precautionary principle says the state and its mechanism shall ensure that no activity is causing any environmental damage. There should be a precaution taken by the state and its machinery, anticipating the damage, not after the damage is done. Polluter pays speak about the damage control after the pollution is happened. where precautionary principle says precaution should be taken before the damage happens. Government should anticipate damage and should take measures. And who will do the damage control? Person who are benefited by the change. Person who is bringing the change. He at his cost should conduct environmental impact assessment and these changes. So all these are part of fundamental rights according to Supreme Court. But we don't have a legal mechanism to implement the same. Because, as I said, the Parliament have not recognized our rights, our environmental rights transformed into a legislative tool where we can go and implement that, use that tool and implement the provisions. We don't have that. Unless the state is not recognizing it, citizens are helpless. The courts, the high courts, Supreme Courts can definitely interfere. They can ask the government to make the law, or in the absence of law, they can create law. Supreme Court under Article 142, there is enough power to create law for providing justice. But as I said, our litigations are in the premature stage where the climate justice is not being recognized as a fundamental right. The students community in the leadership of Greta is on the street questioning the very policies of the state. But there is no corresponding statutory mechanism to implement that. So, as a lawyer, we are facing the first difficulty that we don't have enough laws to address the new coming issues of climate change. Second thing, about compliance. There are several laws, water prevention of pollution in water, air, environment, environmental damage mitigation. We have so many laws. Where is the compliance? Who will see that the laws are complied with? There is no regulator in the country. There is no regulator. There is only a license giving mechanism by the Ministry of Environment, Forest and Climate Change. They are giving licenses. They are giving permissions. You convert this much of tiger reserve into a tourism area. You convert this much of forest into a mining area. You convert this much, you create this much of thermal power stations. It is a need of the country. Yes, there is a licensee. Who will see that the conditions in the license are complied with? There is no mechanism. There is no regulator in the country, and Supreme Court has directed the central government to have a regulator. In 2012, there was a contempt of court case which says the regulator should be implemented within 6 months, appointed within 6 months. We are in 2023, there is no such compliance. So I can say 100 judgments of the Supreme Court, 300 judgments of the High Courts, 1000 judgments of the National Green Tribunal are not implemented by the state. So unlike in the other countries like US where the corporates are directly violating the laws, here the culprit is the state. I can state with examples. I'm sorry that I couldn't prepare a PPT, but I can tell you with confidence who is the biggest polluter in the country? Our state. Because of three things. There is no legislation, there is no regulator, there is no compliance. If these three things are not there, how can we call that we have a rule of law? We have rule of law for traffic. We have rule of law for transportation. We have rule of law for building construction. If you construct more, it will be demolished. Where is the rule of law for environmental rights? It is not there. Ideally, let us come into the practical side. Ideally, if you face a violation for your right to get any of your rights with related to environment, like I am polluting your well water, what is the way out? You go and file a litigation, a suit before a civil court to inject me from polluting. There are so many such issues, environmental issues. I am polluting the air. You are living nearby. I am taking more well water for my commercial purpose where you are losing your drinking water. So many. You can fill the blanks. The civil case between two persons for their environmental rights, that will be unending. I can say for the next 25 years, these two people will be standing in the court. There will be no end to the civil suits. So what is the remedy? Parliament has recognized the right to get such laws implemented fast through a tribunal. That is called National Green Tribunal in 2010. Enough power, even to regulate the state, even to ask questions, to punish the government officials. National Green Tribunal has got power. Every citizen in this country can go to National Green Tribunal if there is an environmental issue, a substantial question related to environment. But we have replaced all the civil courts in the country with one green tribunal. You know what is the impact? Kerala alone have around 150 to 200 civil courts where the civil disputes were going on between persons with respect to environment. It can be several issues, as I said earlier. Tamil Nadu have more than 350 civil courts. Karnataka also do have such numbers. Andhra and Telangana have around 500 or more civil courts. Every civil court will have some jurisdiction, like in one district there will be 3 or 4 or 5 civil courts. We have a National Green Tribunal bench in Chennai, which replaced more than 1,500 civil courts. All the civil cases where environment is a subject matter will be transferred to the National Green Tribunal. You cannot approach your Pattadipalam Civil Court or Edapalli Civil Court or Ernakulam Civil Court to adjudicate your environmental issue with your neighbor or with your corporation or with your municipality. You have to go to minimum Chennai to raise this issue as a litigation. I can say 1,500 judges who were hearing the environmental litigations have been replaced with one judge. We can imagine the effectiveness of the tribunal. Who will go to that? Justice is directly depending upon the distance between the court and the litigant. That is very obvious. If our court is in Delhi, we know how many of us can go to Delhi and conduct a case. If the court has come to Ernakulam, it will be easier for us. Access to justice is directly proportional to the distance from the client and the justice delivery system. We have only 4 or 5 benches in the country for adjudicating the whole environmental issue. Who is raising this in the parliament? No one. So our legislators are also not addressing the issues that we are facing. The National Green Tribunal Act says every litigation should be heard finally and decided within 6 months. There is a provision for that, 6 months. I can say not even a single case. Not even a single case out of 1,000 cases being filed every year. In every bench, not even a single case is being disposed of within 6 months. Or for the namesake, they might have disposed some cases. Yet like that, giving directions. If you have still problem, you come back again because our time limit ends. So there is no access to environmental justice. There is no legislative tool to implement environmental justice. And thirdly, about the compliance. As you know better than me, our executive is more corrupt than judiciary and legislature. So there will not be any compliance. If you want to get compliance of the environmental regulations of this country, whatever is available, if you want to get it implemented, you have to pay from your pocket. Either through a public interest litigation or through your own litigations, you have to go to the court. Suppose a thermal power plant is emitting more carbon. We have one in Kochi, that is Cochin Refinery. Cochin Refinery is refining the whole petroleum for the 2 or 3 states. around 50 to 100 residential units are there in and around that place. Everyone is suffering. They would say they can't, light their kitchen cylinders. They can't use anything, any fire equipment in their residential building. They can't breathe properly because of the over contamination in the air, petroleum products. So we can't point out fingers to those polluters. Why? Because there is no implementation. The agencies who want to implement those things, who are duty bound to do that, are silent. So you have to spend from your pocket, go to court, get these laws implemented against the biggest polluters. And there is no remedial mechanism as per law. Suppose you prove that you have sustained an injury of say 1 crore rupees. You have lost your father or mother or your child due to this pollution. Suppose you prove it in the court. Where is the mechanism for giving compensation? Bhopal happened in 1980s. Around 40 years. There is no legislative mechanism for fixing the penalties. I am not saying negative things alone. I am saying these are the lacunas where we face. As a litigant, you will face tomorrow when you face a basic environmental issue. Environmental issues are not theoretical, not academic environmental issues, not at all. When you face an issue with respect to your drinking water, it is your fundamental right. It is not about academic discussion. It is not about the theories that we have learned in our high school classes about environment. It is about our right to life, nothing less. So when we face that, we can understand that these are the lacunas. Who will speak for this? Who will bring the solution for this? I can say that every right that we are enjoying today, including our independence, is a result of the voice that we have raised. Consumer protection movements in the country in 1990. Now we have billing system. If we complain through email, there will be a result, or else you can go to a nearby consumer redressal forum, you will get the compensation. You have a system. So companies are aware that they cannot simply cheat the customers. Likewise, only a proper understanding about the rights, environmental rights, the issues that we are facing, like climate change issues, that proper awareness will create a movement where people will demand for a proper legal system where we can go and make the people accountable. I am pretty sure that the class who are ruling in this country, whether it is a legislator or a jurist or a judicial person, a judge or lawyers community or the executive who are working with the government, they may not be the victims of climate change. They are living in a better environment. The persons who are actually going to affect is the poor people who don't have much land, who are staying in the marshy areas, who are directly depending on the environment, like catching fish. Fish catch, you can see, for every 3 kg of materials that is being brought by the fishermen through their net, 1 kg is plastic. 1/3 of the total catch is plastic. Can they file in litigation? Can they fight the cause? They can't. So, it is the right time to think about a awareness creation. Litigation point of view, we are facing a lot of difficulties. I think I'll speak about in some other session. Practical difficulties are there. How to prove? Court will always ask prove. The jurisprudence says it is the burden of the other side. Those who pollute shall prove that they are not polluting. Those who want to create something, construct a building, construct a road, construct a rail, it is for them, their burden to prove, otherwise to conduct environmental impact studies to show that we are not doing any harm to the environment. But the court will always ask, if you are accusing someone, prove yourself. That is lack of awareness. That is lack of general awareness about environment. And if you go into details of environment, then we can say each and every organism living around us are also having the same right to life. We have recognized that. As human beings, as a country, we have recognized the right to life of every small creature that is protected under Biological Diversity Act and Environmental Protection Act. But we don't have mechanism to recognize. It is for us to recognize. It is for us to change the living system, administrative system into an environmental governance system. I hope that this kind of small sessions can make a wonder, because if the idea is communicated to the public, definitely people will start thinking about that. Supreme Court has said environmental protection should be a part of our 10th standard curriculum. I don't think that is implemented yet. I'm crossing my time limits. I think I can expect some questions or some interaction.
Yeah.
Sorry for my one-sided.
Thank you so much, Harish. That was very so bone-chilling statistics, and that kind of hit at the bottom of our lack of awareness. Really, for us especially, I think we've never thought about how is this really achieved. Right next door, we have a borewell that's pulling out water and commercially selling, of course. Whereas our well here has been there for 50 years almost, and only is used for watering the plants. Of course, we've thought about what we should do, but we know that it will be years before anything can happen. If anyone has any questions, you can speak with, you can ask now or interact with Harish even a little bit after we close the session. We're breaking for lunch immediately after this, and we'll be back at 2:15 with the next film. So, any questions, anyone? Nitin can pass the mic to you.
Yeah, do you...
Hi, your name?
Sorry, my name is Jeffrey. I'm coming in from Kottayam. I've been here now. Anyway, long story short, I'm very interested in this topic. Very concerned about what is happening in a lot of places around my house, in Kochi especially. Whenever I come to Kochi, it's a shock. And I leave Kochi, I'm sorry to say, because of the pollution and stuff. But do you do any kind of awareness, blogs, videos, anything where we as citizens can be more empowered and learn more about what we can do? Is there anything you do in this regard?
I personally am not doing that. I have been in television channels. I was talking on environmental matters regularly on subjects, and I was attending. I can say I have attended more than 300 sessions on school or college students where environmental awareness is basically being created. And personally, we have. I personally am involved with an NGO called One Earth, One Life, where they were doing a lot of camps, forest camps for students. I think I was a part of that till I focused on my advocacy in 2013. So 10 years we worked on that. Now the awareness is very limited on the what we call sessions. And secondly, the environmental awareness campaigns are there in social media generally. I do write in social media, of course. Environmental matters, when it comes to EIA 2020 draft, there was a huge campaign. I was also a part of. only selectively people are asking about such things. Otherwise, there is no general, as you said, there is a vacuum for that. We are trying to create one space where we can, get these kinds of videos. I'm not an expert in environment subject. I'm only a lawyer turned environmental. So, persons who are actually involved in the environment sector can do much more on that. I think what is the relation between a human being and an ant, or an elephant, or a bird which is flying from polar regions to our area. So this kind of interconnection between the organisms, I think people should understand that first, because law is a very dry subject. Explaining law may not be fruitful for persons, but explaining environment as a system, coexisting system, they will definitely help. I think persons who are working in environment as a subject should create more awareness. Definitely, it is call to take. I will also try to take some blog or something.
One last follow-up question. You are saying that the National Green Tribunal is not effective because it is one place with thousands of cases that used to come to all the other civil courts regarding environment. It's all going to the NGT and there is no implementation in 6 months. So you said these mechanisms did not exist before for other things also. Implementation was not happening in other aspects also before. How, maybe I missed it, how do we bring implementation into environmental issues?
Good question. Before National Green Tribunal, there was no implementing mechanism for environment per se. It was the high courts in the country who were doing this. That people used to go to high court and get things implemented. Very rare litigations, and all those litigations are as a part of environmental history. It's a part of environmental history because MC Mehta cases, so many cases filed by Goa Foundation, so many cases are part of history, because every litigation at that point of time, environmental litigations are one of the major sources of environmental laws in the country. We don't have laws per se, rules per se, but environmental judgments, environmental litigations have converted into environmental jurisprudence. So, in that sense, the high courts were doing that. But high court, the limitation of high court. A general example is being quoted everywhere, that in Maharashtra, when one person raised an issue of acidic waste disposal to a nearby river, that river got polluted and its acidity was shown as, pH value was shown as 3.7. So the High Court judge, while hearing the case, said the normal pH is 7 to 8. It is only 3.5. So you can permit it because it is very beyond, it is very within the limits. So the understanding of the subject is also very important. 3.5 means so much acidic where people can't even use that. So that kind of lack of information is there. So generally, then at that point of time, high courts started leaving all these things to civil courts. Then comes the role of National Green Tribunal. Initially, National Green Tribunal was very effective because they have two powers: hearing appeals on the licenses granted. Then they have original power to restrict the pollution, grant the compensation for victims, and taking remedial measures as well. But there are only 4 or 5 benches in the country, and retired judges are being appointed as judges of National Green Tribunal. What will happen? Only judges who were sitting in high courts, who were favorable to the central government, alone will be appointed as judges of National Green Tribunal. Only yes men people. So all the judges who are appointed as National Green Tribunal judges are yes men people. The first person was a very good person who wanted to create a difference. He acted something. So the second appointment onwards, central government took a very stringent view that only yes men people will come there. Now it is almost ineffective. Like orders, if you notice the act, there is a subtle difference between a high court judgment and a National Green Tribunal judgment, wherein if a high court judgment is violated, the remedy is to file a contempt of court case, where you have to prove that the respondent has violated this with intentionally. That means intentional violation alone will create some sort of result. Suppose the respondent comes and says, it was my mistake, but I couldn't implement it properly. Then it will be pardoned. There is no contempt per se. Contempt is only when there is a purposeful disobedience of a court order. But as far as Green Tribunal Act is concerned, every order of the Green Tribunal should be implemented. Otherwise, it's a criminal offence. Then the secretary of the department or the person concerned, this may be a panchayat secretary or maybe a district collector, he can be personally liable and put in jail. But from 2010 to 23, not even a single case has been registered anywhere in India for violation. Why? Because as Chief Judicial Magistrate should take the cognizance. Only if a central government officer files a complaint that this order is violated. Who is violating this? The central government officials. Who want to file a complaint under the Act? Only the central government official. So that won't work. So generally it is ineffective on these aspects. Even if we have provided so much of, and the last part, please don't think that thousands of cases are coming to NGT. Nobody is coming. You see 2010 to 15, number of cases have been increased, the result was very huge, so many projects have been stopped, like Aranmula Airport project was one of them from Kerala. 500 acres of wetlands were protected by that judgment. Thereafter, there is no effective mechanism to deal with the cases, so nobody goes. So every person who is not going to Green Tribunal, Chennai or Delhi, some cases are in Delhi, where national important cases are there, they don't have the material means and ways to go to that place or find a lawyer, file the case. So unfiled cases are more than filed cases, and the number of appeals are also getting lowered. Initially there were in Chennai bench, I remember 300 to 400 appeals were there. Now it is not there. Now the Green Tribunal is being converted into a forum where companies are going against the rejection of clearances. That is also a forum now. If you have the power of appeal, definitely you can challenge the licenses granted as well as licenses rejected. So government is having an understanding between companies, with the companies. Suppose you are filing an application with me, I am the government. I will reject it because there is a public protest. I will reject it. You file a suit before the appeal before the Green Tribunal. There is a lawyer who is standing for me and standing for you. Both are in agreement. You will get a verdict from Green Tribunal saying that you can go ahead with the project. Because I will not furnish any of the documents before the Green Tribunal to substantiate my case. So you will succeed. So litigations have become a facilitation center for violations and facilitation center for flouting the laws. I cannot permit you to violate. The court can permit. Nobody will ask the court. There is, in the whole system of judiciary, there is no accountability to judges. Suppose a collector says, I permit your violation. Collector will be penalized under Prevention of Corruption Act. It will be a corruption. A judge, through his judgment, says you can continue your violation of taking her well water and commercially use. The judge will not be penalized. Suppose, even if the Supreme Court finds fault with the judgment and per se say malified intentions, he will not be punished. He is protected under the provisions of judiciary. So judicial forums are now more being used as a facilitation center for violation which cannot be permitted by the state. The remedy is to have a public awareness on that. For that we need data. Out of 300 cases filed, how many of them have succeeded? How many of them have failed? What is a failure? It will be dealt with academic people like law students or universities who is teaching law. But I have not seen any reports from any of the law universities where they are focused on the result of judiciary. Have you ever seen any report out of 10,000 cases filed in Kerala High Court for, say, for fundamental right violations? this many number has succeeded, this many have failed. We don't have such data. Why we don't have such data? Because judiciary inherently works on the lack of public auditing. There is no auditing on judiciary. Absolutely no auditing on judiciary. Judiciary is the most corrupt system in that sense, because it is not corruption with money. It is corruption with facilitating violations. It need not be environment violations, any kind of violation. Judiciary is not on the audit side. Suppose executive violates, judiciary punishes. Executive violates, the legislature can call him and punish. Legislature violates, judiciary can step into and punish even the governor or the chief secretary or even the chief minister. But if the judiciary violates, there is no mechanism to deal with.
That's very interesting. Put very nicely, I think. Yeah.
So I think the time
we'll wind up, because 45 minutes for lunch. Quickly go grab a bite outside and come back. 2:15 we'll be screening the next film. And if anyone wants to chat with Harish before he leaves, you can have a quick 5 minutes chat. Is that okay with you? Yeah. So, Against the Tide is what we are playing at 2:15. So, if you need suggestions for lunch places also.
I have seen one word called co-extinction.
Co-extinction and coexistence is a big exhibition that's traveling around the country, but co-extinction,
We are going to perish.
We are going to perish, I want to end on a positive note.
No, all these are awareness.
Yeah.
Like, if we won't act in time, we will face all these things. I would say Delhi, if you see as an example, Delhi is most polluted city in the country. Every judges, every legislatures, prime minister, everyone is living in Delhi. Delhi is the most polluted area in the country. Every city like Kochi is learning to become a Delhi. The design is in such a way. Bangalore was a livable city earlier, now not. There is no water, there is no groundwater. And the last flood resulted in an aware. See, every disaster brings a more awareness. ഈ മലയാളത്തിലൊരു ചൊല്ലില്ലേ, അടി ചെയ്യും ഗുണം അണ്ണൻ തമ്പിയും ചെയ്യില്ല എന്നൊരു ചൊല്ലുണ്ട്. നല്ല അടി ചെയ്യുന്ന ഗുണം അണ്ണൻ തമ്പിയും ചെയ്യില്ല. When we face disaster, everyone understands things very easily. 2018 flood taught Malayalis you should not construct anything within the riverbed or nearby, because it will be affected. Landslides, there is landslide area where we should not invest for resorts or whatever. So that kind of awareness is coming through disasters. Delhi is a disaster. I don't know how far we have learned from that, but Kochi is going to be, because air pollution level is very high here. Tribunal is learning, it's in that process. So I'm saying people are seeing a change. Those who went back to their villages in the lockdown period, my friends who are working in Bangalore, Bombay, Delhi, they all came back to my native place, and they were all in their house work from home. Now 2023, their companies asked them to come back. It is very difficult for their children to go back, because they enjoyed the freshness of undeveloped air. So this undeveloped air, when they were enjoying, now they can't. They are suffocating in Bangalore, Delhi, etc. So they are seeing a change. They are facing a real-time impact. I think a pull will come from their side. We have to channelize it, as you said. There is enough information in the room, but we have to channelize it.
Thank you so much. Thank you so much.